on anti-SLAPP legislation. I'm Michael Hayes in our Government Affairs Department. I have an extraordinary panel here with me: Ian Adams from the R Street Institute, Laurent Crenshaw from Yelp, Tom O'Brien from Glassdoor, and Sasha Moss, who is counsel for Congressman Blake Farenthold. Today we'll be discussing exactly what a SLAPP is and why you should care about it. We are not talking about slaps like slapping you with a giant hand, right? We're talking about slaps with 2 Ps, and that stands for Strategic Lawsuit Against Public Participation. These are bogus lawsuits that people try to use to silence critics, to try to silence opinions that they don't like. There's no merit to the lawsuits. They simply exist to try to scare someone into taking down their legitimate opinion, their free speech. So would love to first go to Laurent Crenshaw with Yelp to talk about exactly why a regular internet user, for example, someone who just posts a few lines on Yelp after having a bad experience at a business, why should they be concerned about slaps?
Thanks a lot for that question, Michael, and also thanks to the Consumer Electronics Association for having this Google Hangout today so that we can talk about this really important issue. So, internet users should care about SLAPP suits, in particular just because of the fact that as online commentary, online reviews, online correspondence continues to have a bigger place within society, unfortunately you have certain individuals and or business owners who decide to use the threat and or actual follow-through of a lawsuit as an excuse or an exchange for good customer service or good business practices. So while Yelp in particular, Yelp as a platform is protected under Section 230 of the Communications Decency Act from statements that are made by users on the platform being an intermediary, what we really care about is making sure that the average Joe Schmo user who happens to write a review about a dry cleaner, a dog walker, a restaurant, or wherever, and it's their honest first-hand experience, that they don't end up actually being threatened or facing a slap because of the fact that they might have shared a negative opinion or an opinion that the business owner didn't like, even if it was honest and truthful. And so really, you know, it's about giving internet users the ability to have, and honestly, to protect their First Amendment freedom of speech to just share their experience and their opinion.
Oh. Absolutely, and that's frightening for an average user, right? Someone who just logs on thinking, hey, I'm going to let people know that I didn't get very good service here, or, you know, my food wasn't particularly good. They don't ever think that they're at risk of being sued over that. They honestly think that they're probably providing useful information to their peers, right?
Absolutely. It's about providing useful information to your peers and to the community at large. That's really what the internet is all about. It's a platform that allows individuals to share their experiences, their thoughts with basically everyone around the world. And unfortunately, in certain instances, you have individuals or entities that choose to use a meritless lawsuit or SLAPP suit, or SLAPP, I should say, as a mechanism for intimidating that speech that's otherwise legal and lawful. And so we really care because obviously, as a platform that relies on freedom of speech in general, we want people to be able to share their honest, fact-based opinions.
Absolutely. And Tom, what's Glassdoor's experience with this? Because I imagine, you know, on your platform, you're dealing with very sensitive information, right? If it's about a current or former employer.
Absolutely. And just for a little background for those of you who don't know what Glassdoor is or what we do, a shorthand way of explaining it is, and Ron, I hope you don't mind, that we're essentially Yelp or TripAdvisor for job seekers. So job seeker will come to Glassdoor, they'll see some open jobs, but they'll also have this access to this ecosystem of user-generated reviews, salary information, benefits information, ratings of CEOs, all left by users. And within that context, it's a forum for users who are employees or ex-employees to talk about their work experiences. So everything that Ron just said about the experience at at Yelp and the protection they're trying to provide users from SLAPP suits applies to Glassdoor, but there's this additional overlay of the workplace experience, the employer-employee relationship, where the risk to the employee of being unmasked as a result of a SLAPP suit brought by their employer, the consequences are much greater than if your dry cleaner finds out who you are. You could be fired by your employer. If you're working at another employer, that employer may not be too pleased. You left a negative review about another company. You have consequences there. And then, of course, there's the consequences to all users who leave reviews on site that they're facing, certainly in our instance, an entity with most likely much larger resources to draw from to file these suits with the objective of either A, just getting the review down, B, scaring the user, and C, doing something to either fire that employee or pursue legal action against that employee, and the employee may not have the same resources, the same incentive to fight it, and the ultimate result is chilling free speech and frightening people from sharing candid discussion of what it's like to work at their company.
Absolutely, I think you hit on something important with the misaligned resources, right? If you are a business, you can easily come after someone, and one legal case may not be a huge financial commitment for you, but for an average individual, if they post a piece of information online, they surely haven't set aside a certain amount of money as a contingency to be paying a lawyer to deal with any consequences of that. And so even the threat of a lawsuit, am I correct, right, would be enough to get them to take down lawful free speech without even ever having a chance to prove their innocence in court.
Absolutely. I mean, even receiving notice of a subpoena can be very frightening to the average user. And I know at Glassdoor we take a very aggressive position about this. We like to fight these subpoenas directly to protect our user base and make sure that employers go through the First Amendment balancing test in a subpoena enforcement action. But nevertheless, it's frightening to users, and those subpoena enforcement actions don't necessarily have the same burden of proof and legal standard that applies in a SLAPP situation. If you had an anti-SLAPP standard that requires a likelihood of prevailing on the merits, that's a greater hurdle for the company to have to get over. And if companies knew that by filing this frivolous lawsuit to frighten their users, that they're walking into a situation where they could be faced with a anti-SLAPP motion, could have to pay the attorney's fees of the user, it can serve as a powerful disincentive for users who are essentially disenfranchised as opposed to the companies who have resources that they could throw at this without it having any effect on them.
Well, I'm glad you brought up the anti-SLAPP motion, right? Because people in different states have much different recourse when it comes to this. If you're in Texas, if you're in Oregon, if you're in California, it's a lot easier to get one of these swiftly dismissed. If you're in one of the other states that has no state protections, you're out of luck. It's a much more difficult, it's an uphill battle for you. So Sasha, would love to hear from you about what Congressman Farenthold's working on with the Speak Free Act about providing some sort of federal backstop so that everyone in America had some level of protection against these.
Well, presently, I mean, a little introduction to the bill itself. It's a substantive piece of legislation, not really procedural and, I guess, entity. It's modeled the present California and Texas legislation. So the main goal, I guess, is to put safeholds in place and kind of bring together the various diverse sections, diverse acts we have state by state wise, so that defendants have an extra option that's bound to them. I mean, there are currently 28 co-sponsors, and we're looking forward to kind of getting this on the road and see what we can do to the common individual. Like Laurent said, we need to have more safeguards in place so everyone can have access to them on a federal level.
Well, let's say under the Speak Free Act, if ultimately we're able to get this passed into law, which I sincerely hope that we would be able to.
Knock on wood.
Knock on wood, doing it now. How exactly would this work? Let's say I post an honest review of somewhere that I previously worked on Glassdoor, and someone came after me for that. Under the Speak Free Act, what would my next step be?
Oh no, go ahead, Sasha.
No, go ahead. Please jump in.
Okay. No,
Please jump in.
I was thinking, well, what we recommend, we would notify the user, number one. Glassdoor as I mentioned, tends to pursue these actions and fight them directly ourselves, but this would give the user a recourse to appear anonymously, file a motion to dismiss the lawsuit. The drafting of the anti-SLAPP statute requires that the company must show a likelihood of prevailing in the merits. So in that scenario, the plaintiff would have to provide evidence to support their claim. The court would also look at some evidence provided by the defendant, which is not necessarily the case in a subpoena enforcement action, and then would evaluate whether there is a likelihood of prevailing in the merits. And if that doesn't obtain, the court will dismiss the action, and the user will be granted the attorney's fees that the plaintiff has to pay for. Now, conversely, if it turns out the action has great merit, to such an extent that it seems like the motion was filed frivolously, then the plaintiff will be awarded fees also. So there is a balance at work there. It's not something that's simply intended to hurt plaintiffs, to dismiss their claims, and make it impossible for them to pursue their claims. But it does perform this winnowing function that also kind of balances the power a little bit between those who have more resources, more of an incentive to file these suits, even if they're frivolous, and those who can now defend them and know that they're not necessarily on the hook for a great deal of resources they may not have, and a great deal of time and expense to go through an entire lawsuit that can now be dismissed at an early stage if it's a frivolous action.
So I'm pulling two key things out of here, right, which are being able to swiftly dismiss this and being able to recoup your attorney's fees, right? You know, most Americans don't have a lot of time to spend in court dealing with something like this, swift dismissal, and particularly they don't have the resources to deal with this. And so attorney's fees, you know, in my reading of this, right, would make it so that an individual could be made whole again, so that proving your innocence would not cost you anything. You know, so just the fact that someone else decided to harass you with a lawsuit doesn't mean that you suddenly are out a certain amount of money for your attorney. Ian, would love to hear how some of these state statutes have worked already. Have there been successes in Texas? Have there been successes in California?
Yeah, absolutely. There have been. In California in particular, which was the first of the states to introduce an anti-SLAPP statute, you've seen a real decrease in the number of the sort of suits or the kind of activity that you've been talking about here. I mean, it's encouraging that we've seen other states and the District of Columbia, 28 at this point, also introduce similar statutes, similar bodies of law. And I would say it's crucial that we move forward and attempt to do something at the federal level. This is from someone sitting in Sacramento, sitting in the States, just because daily I see attacks on state-based anti-SLAPP laws. For instance, in Nevada this last session, there was a terrible bill that passed the Senate unanimously that would have taken out the provision of the anti-SLAPP law that is the economic teeth, right? The idea that you can recoup the costs of the attorney's fees. So that would have been removed entirely, and that was just a single person, pretty much, who got sick of the anti-SLAPP statute because, well, it was Steve Wynn, and he'd had a bad experience with it, and so he decided to get rid of it. And in the end, you know, a coalition was able to get together to make sure that the law that eventually passed didn't water down the anti-SLAPP statute too much, but it seems to me that you need a federal answer here, just because it's not as though the tide always is going to go in the right direction when it comes to the states. It can also move backward, as we've seen in Nevada and as we've seen in states like Washington.
And right, how many states are there right now that don't have any federal or have any state protection from anti-SLAPP? It's in the 20s, right?
Yeah. 22.
Approximately. Yeah, 22 is correct.
Yeah,
that's right.
I'm doing the math off the top of my head. It wasn't great.
I thought there are 26, right, that have some level of protection, but even that's fairly disparate, right? Some are offering much more protection than others.
Currently 28, just because I believe that Florida just adopted theirs as well. Went into effect on July 1st, and there's in regards to the overall standard is better than most have been. But you are correct that some states, I believe, like Connecticut and others, while they may have in Pennsylvania, while they may have anti-SLAPP laws on the books, that they're very narrow in scope and either apply to instances where a governmental entity might sue an individual or just some subsect there. So it doesn't really apply to the instances that both Tom, or that Glassdoor and that Yelp are really concerned about here, which is protecting broader speech in the general public. And reporters also care about these issues, especially now that most of the reporting happens to take place online. And then you also have to consider that one of the things that the Speak Free Act would do as well is that it would actually apply the anti-SLAPP laws at the federal level, because there was an issue in Washington, D.C. actually earlier this year where they attempted to use the district's anti-SLAPP statute in a federal case, but the courts denied that. And so it's problematic there, and so that's another area and another reason that we really need to have a federal anti-SLAPP bill.
Yeah, so
Laurent's dead on, because it's the same. The Ninth Circuit out here in California allows the use of the state anti-SLAPP statute in the federal courts, where the First Circuit in Massachusetts, it's no go. And so just having that patchwork approach, having your First Amendment rights essentially like coming down to where you sit at any given time, that's absurd.
No, absolutely. So if I'm in certain jurisdictions, in certain states, in certain courts, I'm absolutely out of luck. You don't have the protections you enjoy in certain other places.
And just one more little thing there in particular to emphasize this from a consumer standpoint, and even I think just in the internet ecosystem standpoint, so much of speech that takes place on the internet, you could have people that are based in Washington, D.C. talking about companies or businesses or other things in California because they happen to travel there. And so once you have this whole question of you know, interstate, and if a business chooses to file in their domicile versus where you're actually located, and especially, you know, it leads to this whole forum shopping situation, or can as well, where large-scale companies look for places that don't either don't have anti-SLAPP laws at all, or that just have very bad ones.
So, Sasha, what's the next step to taking care of this? What do people need to do to help get the Speak Free Act across the line?
To be quite frank, there needs to be more awareness in the general public. I mean, we have our Google Hangout right now, some great companies like Yelp and Glassdoor, and great think tanks like R Street on board, and CEA as well. But we need to get back in general consciousness. People need to understand that this is a First Amendment issue. They really just need to see how it affects them on the base level. Like, the personal stories are always great. More awareness is possible we can get out, and just talking to their friends. I think it starts at the constituent level and moves its way up. So keep talking to people, quite frankly.
And from CEA's perspective, we wanted to make it a little bit easier for people to contact their member of Congress and tell them that they should support the Speak Free Act, that this is something important to them. So we set up a website, actually. If you go to declareinnovation.com/sharing-economy, you can log on there very easily, contact your member of Congress, and send them a general message or a personalized message about how you have interacted with anti-SLAPP laws or experienced some sort of stifling of your free speech. Again, like Sasha said, you know, it's personal stories. Members of Congress need to hear about why this matters to the general public. Laurent, you touched a little bit on reporters caring about this. You know, Ian, I'd love to hear from you about some of the other broader interests that care about anti-SLAPP.
Well, I think right off the top, this is an interesting area of law where you've got pro-consumer, pro-business, pro-speech, pro-press, pro-academia, just anyone that has something to say. They're going to benefit from this, and particularly in the context of the internet, because so many of the services that we rely on at this point online, they are what they are because of the online trust mechanisms involved. And if it comes to pass that people are no longer able to trust what they read online because there's some fear of litigation that's just running below every single one of these arm's length transactions, it's not only going to be a problem in the short term, it's going to be a problem in just the way that people begin to interact with one another. So
yeah, that's frightening. It even scares me to think that I could go online and suddenly, out of the blue, get hit by a lawsuit just for talking, just for expressing an opinion.
And
that's crazy.
Michael, I think that there's something else that we should probably make clear here, because, you know, as you've got representatives from Glassdoor.com and from Yelp on here as well, and so sometimes people might say, if you're the business owner, if you're someone sort of looking at it from the other side, you might say, well, what's my recourse if I don't believe that that statement that's been made online is true or that was stated there? And I think that one thing that we should make clear is that our platforms and any other major internet platform that's out there, generally speaking, has numerous tools already in place that you can use to flag or respond to a review that you don't believe, or I should go beyond a review and just say a statement that's not honest or truthful. But in the context of when you're talking about a business in particular, I know for Yelp, we have within our terms of service things that say that it has to be an honest and truthful and first-hand experience. You can flag those reviews. You can go through a whole process if you as the owner or someone else don't believe that that statement that was made there is factual. But beyond that, it's really about, otherwise, if it's within, or I should say, if it's within that ecosystem of being truthful otherwise, then that's what we're really talking about. Then it's protected speech under the First Amendment, and it should be allowed to remain online for everyone to see, whether it's positive or negative.
Yeah, no question at all. I am 100% with you there. As an individual user, I can say with knowledge of this, I even didn't have a full sense of how at risk you are, and your average internet user who's on Yelp or Glassdoor or anywhere else certainly doesn't. And not to mention the individual who isn't even online, right? Ian, this could even affect someone that wrote an op-ed into a newspaper or something like that, right?
Oh, potentially, absolutely. It just has to well, think about it. You had the case recently where Mother Jones was hit with a suit when an op-ed was written on its site, and a billionaire didn't like the characterization, and it was difficult to see what he was getting at in terms of his cause of action. And fortunately, given the jurisdiction that they happened to be situated in, an anti-SLAPP motion was available to Mother Jones. And allow me to say this, it's interesting just from the free market perspective how important this becomes, because you'll see various market players interact with one another and bring suits to attempt to stifle the disruptors, the innovators, those that are new on the scene, and those that really are in danger in the event that costly litigation, creeps onto the web search that you do when you're looking at them, because investors, consumers are going to become aware of it, and for the incumbent player, time's on their side, resources are on their side. So it's not only individual free speech, there's also a commercial rationale, a free market rationale for having a federal anti-SLAPP statute available.
All right, well, I want to give people one more chance to, upside down sign won't do us one bit of good, one more chance to log on and tell your member of Congress how important it is to do something about this and make sure free speech is protected in all jurisdictions, in all courts. Declareinnovation.com/sharing economy. Sasha, I know that you have to jump off here pretty quickly. Wanted to give you a chance to give us any closing words on the Speak Free Act and the way forward here in Congress.
Well, quite honestly, just final comments would be, I mean, this might seem like a larger issue, something that really can affect you. When you think of someone attacking you personally from something you put online, it seems almost in the clouds, but it happens quite often, and it happens often enough that people should be aware that we are taking note. So finally, just contact your congressmen, get moving, and help us help you in the long run. And I do have to run, so thank you so much for hosting the CEA and all my colleagues as well.
Thank you so much for joining us.
You have a good one.
Thank you so much for working on the Speak Free Act.
Thank you.
So any final thoughts, guys?
Well, I would just like to jump on Sasha's point of how real-world examples are particularly helpful to drive this home for people. We just learned on Friday of a lawsuit that was filed in Massachusetts by a company that's suing reviewers of 10 reviews. And I should point out, increasingly we're seeing this when companies are filing these lawsuits. They're not just pointing out 1 or 2 reviews that they have issue with. They're corralling 10 to 15 reviews, really looking to eradicate the negative statements about their company that appear on a website. And in and among those reviews, it's possible there's 1 or 2 reviews that are stating factual statements that could be proven true or false. But by and large, many of them are just opinion. And so one example, it's very brief here. There was a review that's a subject of this lawsuit. Talks about pros are intelligent coworkers in a new, albeit small, Boston office with networking opportunities. And the cons are high turnover, subpar management, undefined vision, and poor morale. Advice, I don't know where to start. And they give the rating of the company a 2.0 and the CEO rating a 3.0, which isn't terrible as far as the CEO rating goes. It's probably better than a lot of people in Washington get. So here's a review, and when the company flagged this review, because like Yelp, we have the opportunity for companies to flag reviews and let us know what's wrong with them. And the company took issue because they said they have meetings where they talk about the company vision, and therefore it's defamatory. Now, for those of us who look at this from a legal perspective, this is clearly someone's opinion. One user can have an opinion that their experience with the company, they didn't see any company vision, and the company itself can have an alternative opinion. And that's why we always say the best recourse is for the company to provide a response on the site that's reasoned and professional, and then when users see that, they can evaluate it themselves. Instead, the company files a lawsuit, and this particular user, who in my mind wrote a fairly innocuous review, is now subject to a lawsuit. They want to find out this person's name, and they want to sue them for defamation, and this is precisely the sort of thing that an anti-SLAPP suit can get rid of. This person could file an anti-SLAPP motion. It would be dispensed with very quickly. They would get their attorney's fees back. Most likely, a pro bono lawyer would take on the case if they didn't have money to advance, because the lawyer would know that they would get the fees back. And this could be dismissed very early. But instead, you have a suit where this user has exposure right now for something that clearly, to me, is protected free speech. And it's the kind of thing an anti-SLAPP statute is supposed to winnow out.
That's crazy to me. If there wasn't a better case for needing some sort of protections, not only to preserve people's ability to express an honest opinion online, but also to preserve an online ecosystem where people have access to information, right? None of these innovative, disruptive platforms work if people can't log on and feel like they are getting an honest expression from someone. So whether it's Yelp, whether it's Glassdoor, whether it's any other forum, online or offline, assaulting free speech, is tantamount to undermining the whole existence of those platforms. It's bad for the users, whether it's contributors or whether it is someone just seeking information.
And I should also point out that this case is happening in Massachusetts, which, and Laurent, correct me if I'm not wrong, it has one of those. It has an anti-SLAPP statute, but I believe it's one of those narrow ones that's limited to some sort of governmental speech about a governmental proceeding. If this individual lived in California, they could fully avail themselves of a very robust anti-SLAPP statute. And there's no reason why, because where you live in the country, you should have a different level of protection for your First Amendment right. And that's why this needs to be addressed at the federal level.
Absolutely. And just to jump off of Tom's point here, I know we're getting close to running out of time, but I think what's really important here, along with everything else that's being said, is that the only way that truly everyone in the general public will know that their firsthand opinions or their experiences when they write them online are legal is going to be through a federal anti-SLAPP statute like this, or I should say, or at least protected, that their statements are protected, is through a federal anti-SLAPP statute. Because one of the things that we're worried about here is that chilling effect. It's not necessarily the person who even gets directly sued, but it's the person who gets threatened with a lawsuit and then just takes down their statement immediately, chilling free speech because they're just afraid at the idea of having that suit in the first place. And the only way that it's going to really end up connecting with people in general that their speech is protected is if there's a federal law. Because of the, we talked about the patchwork, we talked about Massachusetts versus California, and if you're in one state, you don't have the protections. If you're in another state, you do. And so the federal law, the Speak Free Act in particular, would eliminate all of these discrepancies so that the people would just generally know what speech is protected and versus what speech isn't.
Absolutely. Well, I appreciate you guys all joining us today to bring attention to this issue, to illustrate why it's so important that we push for a federal solution to this and talk about exactly how a federal solution in the form of the Speak Free Act would actually work. So I hope this is the first step of moving the Speak Free Act through the House and ultimately getting some federal protections in the law.
Thank you.
Thanks again.
Thank you.
All right. Take care.